I'm Katie Spadoro with Cyber. It's June 5th, 2020, and I'm here with your weekly small business HR update. This has been a rough week overall. It must be recognized that so many individuals have been seriously impacted by the tumultuous issues we are currently dealing with as a country. At Cyber, we firmly believe in diversity, inclusion, peacefully protesting, and the value of all lives. If you have any questions on how to handle these issues at your growing business, please reach out to us directly. On to the weekly news. First up this morning, former employees of Tacombi, a Mexican restaurant in New York City, filed an action against the company on May 15th, alleging bad faith violations of the FLSA and state law. The plaintiffs worked as porters and claimed that they were not paid for all of the hours that they worked. This resulted in their pay rate falling below the minimum wage. They also alleged that Tacombi had adjusted their check stubs to reflect inaccurate wages and hours worked, which would constitute a very willful violation of laws and record-keeping requirements. The plaintiffs are seeking back pay and damages. Under FLSA, all employers are obligated to keep track of non-exempt workers' hours and pay them accordingly, including if excess hours result in overtime. Remember that FLSA applies to all employers, even those with one employee. The FLSA also includes strict record-keeping requirements. FLSA claims can add up quickly, and plaintiffs may be entitled to double damages if the violations are considered willful. These wage and hour claims are a top concern for employers. What are some takeaways for your growing business? Consider a pay practice audit. Your HR team or cyber can conduct a thorough audit of your pay practices, policies, and exemption statuses for your employees to make sure that you are complying with the FLSA. Additionally, if you are located in New York, like this company is, you are subject to special notice requirements for employee pay. The state law requires employers to give written notice of wage rates and other information to all new hires. Give us a call if you need assistance with your state's specific requirements. If you have a growing business and you're interested in learning about an FLSA review at your company, let us know, please, and we'll help you out. Next up, we have a court case that is involving absenteeism. We know that this is a very common concern in small businesses that we work with. In this case, the 7th U.S. Circuit Court of Appeals ruled that an employee's unabated absenteeism made her unqualified for her job and protection under the ADA. Elizabeth Mowens worked for the City of Chicago. The City of Chicago granted her adjustments to her schedule to accommodate her disability under the ADA. However, Elizabeth continued to miss work and was absent 50 times in 1 year. She was suspended twice for her attendance issues, and she was eventually fired. She sued, alleging that the employer failed to accommodate her disability and violated the ADA. The employer argued that her chronic absenteeism made her unqualified for the job, which is a prereq for ADA coverage. The district court agreed with her employer, stating that an employee whose disability prevents her from coming to work regularly cannot perform the essential functions of her job. Even after she was given multiple accommodations, including an extended leave, shortened workday, and a delayed start time, she still missed work over 50 times in 1 year. As a summary, the ADA protects employees with disabilities who can perform the essential functions of their job with or without reasonable accommodations. The ADA requires that employers accommodate workers with disabilities, but essential functions do not have to be removed. The question of whether attendance is an essential function of a job can differ depending on the job. Courts have ruled on both sides of the issues. Courts often review job descriptions to determine the essential functions of a job. The EEOC even issued guidance to employers to have a complete and up-to-date job description that accurately reflects an employee's duties before hiring for the role. According to the EEOC, a written job description will be considered as evidence of essential function. These job descriptions can be a very helpful tool during litigation. At Cyber, creating thorough and accurate job descriptions is one of the first steps we take when we begin to work with a client. We can help you walk through this process and ensure that your job descriptions are legal and complete. Don't forget to have your employees sign off and review their job descriptions. Be sure to follow us on social media so we can keep you up to date on any latest developments for your growing company. In another case involving Title VII of the Civil Rights Act, the EEOC filed suit against a frozen food producer, alleging that they failed to hire non-Hispanic applicants because of their race. The company is a California-based producer of Mexican-style desserts. According to the lawsuit, they favored less qualified Hispanic job applicants over all other applicants of a different race or national origin. The company even went a step further and discouraged non-Hispanic applicants from applying for the jobs. In a similar case, the Marquez Brothers International agreed to pay $2 million to settle for refusing to hire non-Hispanic applicants for unskilled production positions. Even though the company had a language requirement, the EEOC determines that the language requirement was unnecessary due to the nature of the position. Title Title VII of the Civil Rights Act forbids discrimination in employment on the basis of race, national origin, among other protected characteristics. HR is often in charge of ensuring that employment decisions are not based on protected characteristics such as sex, age, race, and national origin. The EEOC also encourages companies to eliminate barriers in recruitment and hiring practices that would discriminate against racial, ethnic, and religious groups, older workers, women, and people with disabilities. Thanks for checking us out this week. We hope that you take care of yourself and you stay well. Let us know if you have any questions on anything that we have covered. You can send us an email at info@cyber.co. Have a great weekend.